you have a valid will, that is what has to be submitted to court in order to grant authority to your named, what we call the executor. They have no authority until a document, the court issues what's called letters testamentary to the executor. And now with that letters testamentary, they now have the authority to deal with bank accounts, deal with the house, whatever assets that are just in your name. But they had to go to court to get that, and that's where they're going to pay all the probate fees. And so having a will is subject to probate. In fact, I've talked about this in past podcasts. The ironic thing is the few times I do a will for somebody, I'm telling them, if you actually do the thing you should do, which is name beneficiaries on your accounts, those accounts have nothing to do with your will at that point. They are outside your will. The only thing that really passes into your will is probably in that case personal assets. And so that's the difference between a trust and a will. Is a trust allows the transfer control of assets from you to somebody else without them having to go to court. They just file paperwork. But with a will, there is no transfer control of assets that are just in your name without having to go through the probate process.